Thank you for listening to Shulchanaruchharav.com.
Who is responsible for paying for the civil court fees involved in a court case amongst two Yidden? As we know, it is forbidden, chas v'shalom, for a Jew to take another Jew, and even a Goy, but that's another discussion, to a Gentile or secular law court, and they must go to a Bezdin. However, often, unfortunately, due to one reason or another, the case ends up in the court, in the secular court, either due to that one side did not want to show up to Bezdin and therefore received a ksav siruv, and the Bezdin gave permission for the petitioner to take him to a secular court, or they went to Bezdin and a verdict was given, but the verdict was not complied to, in which case the Bezdin gives permission for the winning party to take his court order to a civil court to have it enforced. Now, going to the civil court involves many different fees. Opening up a case, file has a fee with it, getting yourself a lawyer, paying for the sheriff to make do of a writ of execution, to collect funds, and so on and so forth. There are various expenses involved for the winning party to try to enforce his verdict from the din Torah, and the question is asked, can he force the losing side to pay those fees or not? In other words, although according to civil and secular law, all those expenses fall upon the losing side who is refusing to abide by the agreement of the arbitration, the question is that valid and correct according to halacha, or is it considered stealing? According to halacha, may you collect reimbursement for your expenses from the losing party or not? So regarding this matter, we find a machlekes amongst the Rishonim. The Rivash in Tshuva 475 and Tshuva Sarashba rule that while it's extremely unfortunate and unright that this losing side is refusing to pay as agreed, and therefore you have the full right and authority of the Bezdin to go and take him to a secular court to enforce the payment, unfortunately you cannot receive reimbursement for your expenses, and therefore calculate well if it's even worth it going to the secular court. Why not? It's so unfair. He's the one causing you. His siruv, his uncompliance is causing you to lose money. They say because in halacha we have a concept called grama, in which we rule that when a person causes monetary loss of someone else in an indirect fashion, he is not held liable to pay in this world. In the next world it's a different story, but in this world we can't hold him liable. And this is a classical case of grama, an indirect loss, so he doesn't have to reimburse. Other Rishonim, however, Tshuvas Harash and others rule that he is liable to pay for those extra expenses and reimburse all the fees, the court fees and the lawyer fees of the winning side, as this is a case of grami, direct loss and not indirect damage. Or we can say even if it's a case of indirect damage or loss, in this case the Chachamim made a fine towards the losing party for his refusal to comply by the din Torah. However way we look at it, we have here a clear machlekes amongst the Rishonim, and how do we rule? So the Mechaber in Shulchanaruchharav Mishpat chapter 14 halacha 5 records both opinions, first the opinion of the Rosh and then the opinion of the Rashba and Rivash, and does not give a final arbitration, although the Ramah there rules lahalacha that the main opinion follows the opinion of the Rosh, that the losing party who is not complying with the din Torah and is now taken to a secular court, he has to reimburse all the money and expenses that the winning side had to shell out to force him to pay. And this includes lawyer fees and court fees, etc. Even for Sfardim, the Mechaber in his commentary, the Beis Yosef rules like the opinion of the Rosh, and hence it ends up that halacha l'maisa we rule that he does have to pay, whether for Sfardim, whether for Ashkenazim, and so also concludes Rameh Mipuno, the Shach, the Rashal, the Sefer V'Sheva Koyin, Muznayin L'Mishpat, Marashda, Aruch HaShulchan, and others. In such a case, the losing party cannot say, Kimli, I hold of the Tshuva Sarashba and I hold of the Tshuva Rivash, who doesn't obligate me to pay. As the halacha has already been sent, like the Mechaber and like the Ramah, that we rule like this opinion that he is obligated to pay. Nonetheless, all this is if the petitioner who is taking it to civil court received permission from Bezdin to do so. If, however, he did not receive explicit permission from Bezdin to take the case to secular court to enforce it, then in such a case, in truth, he would have no right to demand reimbursement from the losing party, and he would not be allowed to do so. So halacha l'maisa, if anyone ever went through a din Torah and the losing party is not paying, or the other party refuses to come to a din Torah, receive permission from the Bezdin to take it to the civil courts, and one may then even halachically justify the placing of all the expenses on the account of the losing party.
Thank you for listening to Shulchanaruchharav.com. Our free services of making Torah knowledge available to the public depends on donors like you. Please help us continue our work through making even a small contribution at Shulchanaruchharav.com under the Daily Halacha Dedication section or in the subscription page. Also, check out our online courses and many sefarim available for purchase that will both enhance your Torah knowledge and help support our work.